Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, we hope that you enjoy this legal education content and that today will be the day that I earn your subscription. For today's case, we're dealing with sexual discrimination in housing. This is the case of Rita Fox versus Lucille Gaines and Dana Gaines. In this case, Miss Fox was able to secure her apartment through the promise of a kiss. But it didn't stop there. 3 years later, she discontinued the physical relationship. Her landlord tried to evict her, and she is claiming that this forms discrimination on the basis of sex under the Fair Housing Act. So in today's case, we'll learn a little bit about the adventures of Miss Fox and her landlord, Scumbag, and we'll learn whether or not she can recover under the Fair Housing Act. Let's get started with this. Miss Fox, a single mother, facing foreclosure eviction, visited the Rose Bush Apartments in Jupiter, Florida, to view an apartment available for rent. When Miss Fox went to apply for the unit, Mr. Gaines commented on her looks, which made her feel uncomfortable. Literally a foxy lady, but that's not really supposed to be part of the housing exchange. Miss Gaines told Miss Fox that he had a list of people interested in the unit, but would keep it available for her if she would give him a kiss, which is almost certainly a violation of the Fair Housing Act in and of itself, not only to Miss Fox, but to these other purported people, if they exist, because you can't discriminate, right? So how about these other people? They're also being discriminated against on the basis of sex now, so if they exist. Miss Gaines' comment gave Miss Fox slight reservations about renting the unit, but because her apartment met her needs, she signed a lease. When Miss Fox met Mr. Gaines to receive the keys, he reminded her about the kiss, and Miss Fox kissed him. Okay, so yeah, right away, we are not in a promising start. This is not supposed to be part of a standard landlord-tenant relationship. Normally, the normal exchange is, I give you money, you give me housing. End of transaction. But now we're involving kisses, and we want to solicit these kisses. If you give me a kiss, I'll keep the unit open. What does she have to do in order to stay there, though? That's where even more discrimination comes to light. So let's learn a little bit about scumbag landlord Mr. Gaines. Upon moving into the apartment, Miss Fox paid for first month's rent, last month's rent, and a security deposit, but she soon found it difficult to fulfill her full monthly rent payment. Mr. Gaines offered to help. How nice. In what manner is his help going to take form? I bet you can guess. He offered to help Miss Fox with the rent if she would help him by providing sexual favors. Miss Fox eventually acquiesced, and for about 3.5 years, Mr. Gaines reduced her monthly rent in exchange for these favors. Miss Fox alleges this arrangement was part of a pervasive and persistent pattern of sexual harassment and discrimination. On top of the sexual favors, if that wasn't bad enough, just to go full creep here, on top of the sexual favors, Mr. Gaines would question Miss Fox about her whereabouts and demand that she not invite male visitors into her home. He also installed surveillance cameras facing Miss Fox's unit and monitored her daily activity. Yeah, so this has gone about as well as you could have reasonably expected. Mr. Gaines over here has the hots for Miss Fox and says, well, in exchange for me lowering your rent, how about you trade me some favors? Which sounds suspiciously like prostitution to my mind. So there's that. But apparently they entered this exchange. Now, he didn't cancel the rent fully. He just gave her a break. So I guess she wasn't that hot or something. But that didn't prevent Mr. Gaines from being super, super possessive, because he would question her about where she was going and say you can't bring other men into the apartment, and installed a surveillance camera to look specifically at her apartment so he could monitor her comings and goings. This is not a good landlord. This is not good business practice, just in case anyone was confused. Both from a legal perspective and from any ethical perspective one could imagine. But, that's the way Mr. Gaines rolls. Okay, let's read more. Hoping to stop Mr. Gaines' controlling and abusive behavior, Miss Fox ended the relationship with him. In response, Mr. Gaines started serving Miss Fox with fraudulent violation notices and threatened to evict her. He is not happy about being cut off from his supply. About a week after Miss Fox ended the relationship, she paid a portion of her rent, as she had for the past 3.5 years, and made an oral agreement with Mr. Gaines that she would pay the remainder within 8 days. 8 days later, Miss Fox paid the remainder of her rent, but Mr. Gaines told her that because she failed to pay within 7 days, he had no choice but to file an eviction on her. Well, you do have a choice, incidentally, even if it's in the lease that you have to pay within 7 days, or whatever the lease provides for. You do have a choice. Just because they're in breach doesn't require you to take action, just FYI. So he served her with a 3-day notice to vacate the apartment for failure to pay rent, even though she owed no rent. When Miss Fox failed to move out within 3 days, Mr. Gaines initiated formal eviction proceedings against her. The day after he filed the complaint for eviction, he and Miss Fox agreed that she would move out by midnight on the last day of the month. On the last day of the month, he called the police and tried to arrest her for trespassing. She explained to officers that she retained possession of the unit until midnight. Now, this can get into an interesting turn of phrase, and one of the problems with saying midnight. When you say midnight of the day, which day exactly do you mean? Because technically, strictly speaking, right, to say I need you to move out by midnight on that day, there is only one time midnight occurs that day. And it's the first moment of the day is midnight. So strictly technically speaking, right, say I need you to move out by midnight on that day, right? So it leads to ambiguity. So who is actually legally in the right on this one? What does on midnight mean, right? Anyways, she promised she did move out later that day, so I guess it's neither a problem one way or another. After being forced out of her apartment by Mr. Gaines, Miss Fox sued him and Miss Gaines, arguing that Mr. Gaines' sexual harassment of her violated the Fair Housing Act and Florida's Fair Housing Act prohibitions on sex discrimination. So we have two different Fair Housing Acts here, right? The federal one and the state one, which can provide different forms of relief because states can always go further. So the district court, though, agreed that while Miss Fox had sufficiently pled severe harassment that was beyond what was required to withstand a motion to dismiss, the court decided that the action was not actionable under the Fair Housing Act. So the district court said this is not a Fair Housing Act violation. The district court acknowledged its holding was in direct contrast with the overwhelming weight of federal authority, but nonetheless concluded the plain language of the Fair Housing Act did not provide a cause for sexual harassment. Okay, so the district court here has to figure out what does the Fair Housing Act mean when it comes to sexual-based discrimination. And the district court does what a district court should do. It looks at the relevant law, and it says, well, I can't find any that is binding on me, like from the circuit. I can't find any. But I do notice that a lot of federal courts of appeal have said this is a violation of the Fair Housing Act. But that's only persuasive authority. So I can disagree. And the court does what it's supposed to do, right? It notes all that and then says, I don't think that's right. I think this is the better legal analysis. I've taken note of it. I note it for its value, but I read it and I'm like, it's just not there. Fair enough. Fair enough. But then, of course, the Court of Appeals can decide what the law is for its circuit because it's never had decided it before. So the circuit could disagree, right? Circuits disagree with each other. So this circuit could go the other way. The question is, will it? Let's read more. Whether sexual harassment qualifies as a sex-based discrimination under the Fair Housing Act is a question of first impression in this circuit. So the district court's like, I can't find anything. Here's what I think. And the Court of Appeals says, you're right. There's nothing. So let's figure out what we're going to do. So the Court of Appeals says we're going to join the circuits that say this is actionable. And then they note here in the footnote that every circuit court so far to have addressed this question has agreed. Which isn't to say they all will agree, but it is to say we're not going to be the first. So, fair enough. We join the so far unanimous consensus that this is sexual-based discrimination. Okay, fair enough. Okay, so in order to determine whether the Court of Appeals is right, we can analyze the statute ourselves, and we can see what it does or does not say, and we can analyze the logic of it. So, good place to start. What does the statute actually say? That's always a good place to start. And then, does this conduct fall within the scope of that? Okay, let's do that. The Fair Housing Act, the actual law, makes it unlawful to, quote, discriminate against any person in the terms, conditions, or privileges of sale or rental of a dwelling, or in the provision of services or facilities in connection therewith because of sex. So you can't, in the course of housing, discriminate on the basis of sex. You must treat men and women the same. The Supreme Court has held that the words because of and based on indicate a but-for causality. So but for them being a man or woman, would you have still done this? The answer is no, you have a problem. The Court of Appeals, therefore, says by its plain meaning, the Fair Housing Act protects a tenant or prospective tenant from receiving differential or less favorable treatment in housing terms, conditions, or privileges if the but-for cause is because of sex. So if Miss Fox were a man, would this still have happened? If yes, it's not sex-based discrimination because it's not because of sex. If it's because she's a woman, it's because of sex. So, yeah, probably because of sex seems like the right answer. Matt asks, so if you're bisexual, does that make it legal? If you, in fact, treat men and women the same, it wouldn't be a discrimination on the basis of sex. Yeah, this has worked. I don't know if it's ever worked in a fair housing case. But I do know it has worked in employment cases. And as the court's about to notice, the courts often interpret Fair Housing Act in the light of the employment cases because they have very similar language. So I don't know if there's ever been a fair housing case at some point, but I do know it has been a successful defense in employment cases where the person says, oh, this is sex-based discrimination. And then the court says, no, actually, they're just an asshole to everybody. So it's not discrimination on the basis of sex. Yeah, they were misogynistic towards you, but they're equally insulting to men or whatever. So it's like, it's not because of sex. They're just an asshole. I'm a universal asshole actually is a valid defense. I've seen it work. So yeah, I suppose if you demand kisses and sexes from men and women alike, it's not a Fair Housing Act violation. So yeah, okay, you can go with that. When interpreting the Fair Housing Act, we, like our sister circuits, look for cases interpreting Title VII, which uses language virtually identical to the Fair Housing Act. So Title VII deals with employment and also prohibits discrimination on the basis of sex in employment. So they both prohibit discrimination on the basis of sex, so the one statute can be informative of the other. Interpreting Title VII, the Supreme Court has ruled without question, sexual harassment is a form of sex discrimination within the meaning of Title VII's nearly identical prohibition on discrimination because of sex. So yes, if you treat your female workers worse or differently than your male workers, that's a violation of Title VII. If you're equally crappy to everyone, though, not so much, but, there is that, yeah. Misandrist is the right term. You're right. I couldn't remember it off the top of my head. Misandrist. You're correct. Well spotted. Following the prior case law, we have consistently held that sexual harassment constitutes impermissible sex discrimination under Title VII in employment, where the but-for fact of sex, she would have not been the object of harassment. So, as long as you're harassing everyone, you're good as far as Title VII is concerned. So, make sure not to limit your harassment only to women. Elidian says, Title IX is usually read this way too, and that they usually read Title VII cases. You are correct, sir. I have seen courts of appeal say exactly that. I've seen them say exactly that, yes. When interpreting Title IX, which deals with sex-based discrimination in colleges, yes, we have seen courts of appeal say we consult Title VII dealing with sex-based discrimination in employment. Now, the next logical question is, if we read fair housing cases in light of Title VII, and we read Title IX cases in the light of Title VII, then would we or should we read Fair Housing Act cases in light of Title IX and or the other way around? I don't know if any court of appeals has ever said that. But that would be logical, right? I mean, they're all dealing with similar subject matter. So, yeah, I mean, if A equals B and C equals B, A equals C. So I don't know if any court of appeals has ever, in a Title IX case, said, let's look at fair housing law, but maybe someday. There's an opportunity there for a lawyer somewhere. Thus, we hold that sexual harassment, both hostile housing environment and quid pro quo sexual harassment, and this would be the latter, quid pro quo, give me sexual favors in exchange for housing, is actionable under the Fair Housing Act, provided that the plaintiff demonstrates that she would not have been harassed but for sex. For the foregoing reasons, we vacate the district court's order granting the motion to dismiss Ms. Fox's complaint and remand for further proceedings consistent with this opinion, which in this case will require the trial court to have some sort of hearing to determine whether or not this discrimination occurred based on sex, or whether or not it didn't. So, yeah, there will have to be some sort of evidentiary finding to find out what is the deal here with the behavior. Is it sex-based? So that should be entertaining. Thus, that brings us to the end of the case of Rita Fox versus Lucille Gaines and Dana Gaines. In this case, Rita Fox wanted to get an apartment. And Mr. Gaines over here said, yes, if you kiss me. And then she said, I'm having trouble paying rent. And Mr. Gaines said, that's okay. You can work off your rent another way. Fast forward 3 years later, she doesn't want to do that anymore. And so Mr. Gaines says, I'm going to evict you. So she says, well, this is sex-based discrimination because you can't do that. And the 11th Circuit Court of Appeals joins with its sister circuits and says, yeah, that's discrimination on the basis of sex. You, if it's true, which of course we have to determine in the first instance. So go back to trial, determine if it's true, and if so, you can get recovery under the Fair Housing Act. And at least for the moment, that brings us to the end of the discussion of this case. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. Until later, my friends, cheers and goodbye.